Good evening, everyone.
Good evening,
Good
ma'am.
evening, ma'am.
Good evening. Am I visible and clear? Audible also?
Yes, ma'am.
Okay. So, did you revise yesterday whatever was taught?
Yes, ma'am, I read.
We'll revise the concepts quickly. Let's wait for a few more minutes and for others to join because there are only 4 people today.
Hi, ma'am.
Hello. Hello, Anju. Good evening.
Good evening.
Are you comfortable understanding the sessions? Everyone? Sayak, Rishabh, Nimisha, Anju.
Yes, ma'am. Ma'am,
Okay.
actually,
Yes,
I had
ma'am.
few confusions in between, so I went and listened again. Then I was able to get it actually when I went to the class.
Yeah, so revision is very important. Revision is very important, particularly for such a subject like CRPC. Was anyone saying anything?
Ma'am, I just had one small doubt. Ma'am, I just wanted to ask if the DM and the executive magistrate can take cognizance of any offense.
Not audible, Nimisha. Only I heard executive magistrate.
Ma'am, can you hear me now? Am I
Yes,
audible?
yes.
Ma'am, I just meant to ask if the DM and the executive magistrate can take cognizance of any offense.
Just a second. Just yes, Nimisha. The DM or the executive magistrate cannot take cognizance. That is very obvious because they cannot proceed with the trial. They cannot take cognizance.
Okay, ma'am, just wanted to confirm.
Yeah, their powers are very limited to the powers of whatever were stated under Section 3 or any other powers which does not which involves administrative functions and not the judicial functions. You can understand it like that. Any other doubts, guys, not related to the concepts? Yes, go ahead. I can see some new faces. Mahalakshmi. Hi, Mahalakshmi. Were you there yesterday? Any other feedbacks? Are you comfortable with the way I'm teaching, or should I improve the areas where should I be slow or should I be a little fast? Any other improvements you guys want me to have in the structure? Because I understand that every student has their own way of understanding, but till the time other people are joining, I just wanted to confirm the feedbacks.
Ma'am, the only thing is that I'm getting confused with the old sections and the new provisions. This is the only confusion, like even when I was listening to. And I was just revising the whole thing and just getting confused between the previous sections and the old sections. So I
Okay.
think when we are going through, if you can focus more on the new sections and the old laws, I think it would be nice, ma'am.
So
Ma'am, do
basically,
we really need to remember the old provisions, like the laws, the numbers?
no, no, you don't have to remember the old provisions. But since you guys have old Bear Acts, that is why I had to write the old provisions. That is the whole point of it. Otherwise, I have the new Bear Act. So I will only refer to this new Bear Act. So I'm only referring to the new Bear Act. Reason behind that is that um there are many changes in some provisions. So I will have to refer to those changes and let you guys know. So that is the reason why I'm sharing my screen also while I'm reading the Bear Act. But since you guys, most of you people have the old Bear Act, which is fine for now, you'll have to purchase it uh in the near future. But if you have the old Bear Act for now, I'll be the one who will be very happy to help. See, the old sections and the new sections are confusing all of us, including me. So there's no point of, getting scared. We have to deal with it for particularly because since you are not a like you are preparing for CLAT where the pattern of the CLAT is not very much section based. That is why you don't have to remember each and every section. Yes, that is what I'm doing. So you guys have to what you have to do is you have to uh remember only the number of sections which I am asking you to remember. I have specifically told in the previous classes, if anyone remembers it, that yes, this is the section you have to remember, that these are the sections you don't have to remember. So if you talk about section 3, section 3 is the section, then section 4, 5 are the sections which you have to remember, which was same before and now also. Then if you talk about section 6 is also same. Then I directly jumped to I guess 21. 21 is the only section which you have to remember, and then the committal and submission sections. That's all. 362 and 364, if I'm not wrong, as per the old laws. Only these 4 sections you have to remember, nothing else. For your reference point and for your Bear Act reading point, I'm asking you to, making you understand the sections again and again. Yes. 362, 364, and 232. So these are the sections till now you have to remember. Three, 4, 5, 6. These are the sections from the new laws. 21, 362, 364, 232. That's all. You have to remember apart from this, how much the High Court can punish, how much the Session Court can punish, and how much the JM courts can punish, including the CJM. Including CJM. JM courts includes JM first and JM second. This is all about the memorizing part. Like you have to learn without any logic. So this also lets me talk about the yesterday topics. Quickly, let's revise what we did yesterday. There were two very heavy topics yesterday, submissions and committal. So first we did committal. This is one thing which you have to remember the section numbers also and the concept also. The concept is very logical and you don't have to remember as such the concept, but you have to remember the number of the sections. It is 362 read with 232 of BNSS. 362 was when, so if this is the chart I draw, investigation, FIR, and then investigation takes place. Then after investigation, what happens? Can anybody tell me?
A police report. Yes.
Charge sheet, ma'am, yes.
The charge sheet, or you call it the police report. Then the court takes cognizance, and then The inquiry begins. No. Before cognizance is 232. It was 209 in the old laws. I'm making you read the provisions today, don't worry. Charge framing. From here, the trial begins. So, if the court take cognizance, the magistrate take cognizance here, if he thinks on two grounds that he needs to inflict greater punishment from the punishment which he is entitled to inflict according to the provisions of BNSS, or you can say CRPC, and the other ground would be the complications involved. On these grounds, after taking cognizance, the court can commit it to only the court of sessions. So committal happens only to court of sessions after taking cognizance. It is 362. But if as soon as the charge sheet is filed and somewhere between this, the court thinks that this is not exclusively tried by me and I need to inflict the greater punishment, or no, this is not exclusively tried by me. Because of this ground, I need to commit it to the court of session. The court will do it under section 232. So this was the concept of committal. Any doubts still here? And I also read some judgments. So for clearance of doubts, yesterday I read some judgments after the class. So for clearance of doubts, committal under section 362, that means after cognizance, can happen before signing the judgment. The judgment. So always remember this, that after taking cognizance, someone had it out yesterday that the court who tries the offense is the court who frames the charge. But no, in case of committal, there might be some situations where after framing the charges, court finds it complicated to be committed to the court of session. And if this is the case, then yes, before till the time till the time the judgment is pronounced and the judgment is signed, in fact, the court can commit a case under section 362 of BNSS. Clear? Till here?
I have a doubt.
Yes.
मैं वो कॉग्निजेंस के बाद डीपी क्या लिखा हुआ है?
This is not DP, this is IOP, issue of process.
उसके बाद में
Issue of process के बाद है documents. Issue of process means calling the witnesses, calling the accused, issuing summons, issuing warrants if required. Documents means giving the documents, necessary documents to the accused. FIR, a copy of FIR, a copy of police report. All those things are provided to the accused as soon as the cognizance is taken. So this is a very small, these are the very small steps.
Ma'am, I have a doubt. Ma'am, in this 362, which you said after taking cognizance, cognizance can happen like anytime before signing the judgment. So, ma'am,
Yes.
the court which do not have the jurisdiction can also try the whole case. And like before the judgment is passed, and like after that, the court can commit it to the session. You mean to say
How
this?
they can, okay, please continue.
My doubt was this much only.
Okay, so suppose, let's understand it again. So suppose a JM first court does not have a jurisdiction to try it. Okay, because it was mentioned that in the schedule, how the jurisdiction can be excluded. Can somebody tell me? Because of which all grounds the jurisdiction can be excluded? Because of which all grounds a court cannot try a case, is not eligible to try.
Ma'am, a court is not eligible to try a case when the minimum punishment for the offense that is being there is
Okay,
not within
that
the.
is one. Lack of punishment ability as prescribed in the court. The other thing is,
Ma'am, same thing with the fine also. If the minimum fine
yes,
that is prescribed.
fine also.
And ma'am, territorial jurisdiction is one other thing.
Area
Yes,
or
yes, ma'am.
territorial jurisdiction. Then the most important is Schedule 1, where it is actually mentioned that which code has to try which offense. These few grounds are the grounds where a JM court or a court of CJM or any of the court are not eligible to try an offense. If all these grounds are there, prima facie jurisdiction is not there, then the court will use 232. Why the court will move ahead with the trial? 232 is, or 209 for the students who are using the old barracks, 232 or 209 is a provision for this purpose only. A person who's not um a perfect, first of all, this is this area or territorial jurisdiction is uh not a thing here, because area or territorial jurisdiction, if suppose JM first is a having a jurisdiction of Bilaspur area civil lines. Just an example. Civil lines. The crime was committed in X Nagar. Of a different district. You can say Raipur. Obviously, the JM will be different. The judicial magistrate will be different. So then transfer amongst two judicial magistrate, the cases are not included here. Transfer among the same authorities, the same level of authorities are not included here. We are talking about submissions and committal, which is going up. Okay. Committal is going up to Court of Session and submission is going up to CJM. If there is a chance that the punishment can be in between 7 years, the maximum punishment is 7 years, JM first will directly commit it to CJM. No, why he will go on trying the case if he thinks that yes, the punishment which needs to be inflicted is more than 3 years but less than 7 years. He will use 232. The cases where greater punishment comes into the picture after taking the cognizance, a court will take cognizance only when, a JM will take cognizance only when he thinks that yes, I am the perfect person to try this case. Otherwise, this will never be the case, that if a person is not even competent to try an offense on the basis of Schedule 1 or on the basis of lack of punishment ability, like for example, JM first, the offense of murder comes into his court. He will not even think about taking cognizance. He will directly commit it to Court of Session because of the reason that punishment is also not under his ability, and the other reason is Schedule 1, which outrightly exclusive jurisdiction to try the offense of murder. Got it? So for all those cases, 232 is designed. For all the other cases where it takes cognizance, but the majority of cases is this. The majority of the cases are this, Because a case where a JM is not even, competent to try the offenses, as soon as the, like, 232 is a very easy section to identify. But on the other hand, 362 is not an easy section to identify. Reason being that 362 depends upon the discretion of the court, discretion of the judicial magistrate to even commit it to the court of session or not. Analyzing the complications, I'm just talking about 362. In case of 362, even before signing the judgment, they can commit it to court of session. Under section 362, competency is not a ground. Under section 232, it is a ground. Rishabh, clear?
It is not clear. I did not understand.
Okay, who else have doubts?
Ma'am, also, section 232 is still about committal, right? Committal before cognizance is 232, committal after cognizance is 362. And section 364 is submission.
Okay, yes. Rishabh, are you clear now?
Yes, ma'am.
Okay, go ahead, Venkat.
Ma'am,
Yes, Aisha.
ma'am, I also have another doubt.
Yes.
So here in this little diagram that you have drawn, so here competency of punishment basically becomes a subset of competency to try, right? Like when a court is committing it to a higher court, it is because they lack the competency of punishment that they become incompetent to try, right?
Right.
No, because initially we learned that competency to try and competency to punish are.
Okay, what is your question actually? The competency to punish. Okay, so for example,
And also whatever like you described right now, also I have I didn't fully understand it.
I'm answering for all the doubts.
Okay.
So for example, a person who's competent to inflict a JM first basically is competent to inflict only 3 years of punishment. Is that so? Right? But if you look at Schedule 1, column 6, he is eligible to try many such offenses where the punishments are more than 3 years. This is what I meant from the statement that competency to try and competency to punish are not coterminous. That means those both the terms, a person who is competent to try, it is not necessary that he is competent to punish. If you'll see sixth column, it is mentioned that by what courts triable. So there are many cases. So this statement, but you can continue. What is the difference between 362 and submission under 364, which ground? Okay. So I'll let you know. Then basically the point here is the limit of punishment is mentioned under the code, but whatever the column 6 says, it is not going in consonance with whatever the column 6 of schedule 1 is saying. That is why it is mentioned that yes, but having said that, a JM first obviously cannot try an offense whose punishment is, the minimum punishment is more than 3 years. How he can try that such offense? But it is mentioned under schedule 1 that by what courts triable. So then the weapons of committal and the submissions come into the picture. Clear till here?
So what I understand is that even though 3 years is the maximum amount that a JM1 can take, in Schedule 1 it is given, they can, attend cases which have a punishment of more than 3 years. So in that,
Yes, but they have to, not the cases where they can give 3 years punishment. Suppose the limit of punishment is 1 to 3 years for one offense. For second offense, the limit of punishment is 3 to 5 years, just for an example. For third offense, the limit is 5 to 7 years. This they have to commit it to Court of Session under Section 232 before taking cognizance, because this is very clear that this is not under their jurisdiction. But under this and under this, they can go ahead. But the second case, under the second case, if moving ahead with the trial after taking cognizance, after framing of, even after framing of charges, they feel that yes, the accused is guilty of the offense and they need to inflict 5 years punishment, the maximum punishment which the section provides, then they will commit to Court of Session. Rather, they'll submit it to CJM, because CJM, how much punishment a CJM is empowered to inflict in terms of imprisonment
7 years.
and fine?
I mean 10,000.
Sure, CJM, Chief Judicial Magistrate.
10
Look,
lakhs, ma'am. 10 lakhs.
sure.
Is
There's
there any limit? I don't think there's any limit.
no
I think it's
limit.
from Judicial Magistrate
Yes.
1 and then.
Yes, there's no limit. Exactly. Good. Whoever are writing on the chat box, very good. But these kind of questions are framed. So that is why I asked what amount of fine a CJM can inflict. So there's no limit. A CJM can inflict as much as fine they want to. Clear till here, Aisha?
Yes, ma'am, clear.
What was your second doubt? You did not understand this before cognizance and after cognizance, right?
Yeah, but now that you've explained this, I'm clear with the concept of commission and submission.
And committal. So before cognizance, outrightly, if the jurisdiction is not there in terms of greater punishment or in terms of Schedule 1, 232, after cognizance, when the court was initially competent, but then after analyzing the case, after taking cognizance of the case, they think that yes, I will not be able to handle it because of the complications or because of any other reason, or maybe because of guys,
Yes, ma'am.
wait. Okay. So if then they think that yes, it is the need of the hour to commit a case to the Court of Session, then they'll use 362. Now answering the question of Anju, what is the difference between 362 and 332?
Ma'am, for that question, one more thing that I think I understood the difference. One is made to Chief Judicial Magistrate and the other one will be to Court of Session. But ma'am, other than that, what is the case that we say that a submission is made and not a committal?
this kind of case, this kind of cases, these kind of cases where a CJM is competent, particularly the cases of negotiable instrument acts, because under the negotiable instrument acts, the imprisonment is very less. If a person gives you a check which is dishonored because of insufficiency of fund, the imprisonment is very less. The amount of fine is double the amount of check. Okay. If the amount of fine is double the amount of check, and if the check, suppose this case comes in front of the judicial magistrate first class, he takes cognizance of this case, because obviously under the Negotiable Instrument Act, it is clearly mentioned that it is JM first. Yes, only Court of Session. Yes. So under the JM, it is mentioned under the Negotiable Instrument Act that it is only the judicial magistrate first class who takes the cognizance of such offenses, the dishonor of check offenses. Then, if he takes the cognizance, and for example, if the amount of the check was, if you talk about the BNSS now, 10K. So the amount of fine he needs to be giving would be 20K, 2x of what is the amount of check. He is eligible, he'll go on with the trial of the case. But then, if the amount of the check was 1 lakh, why he'll be going to court of session then? There's no point of going to court of session for giving a very small case of negotiable instrument act of dishonor of check, right? Because CJM can give any amount of fine, right? As you all answered that there is no limit. So this is the practical application of it. He'll use the tool of submission. Submission happens to only CJM. Which section?
325 is the old line.
364.
Yes. 325 of the old law, 364 of the new law. Nobody is going to, I'm again repeating because many students have this doubt. So nobody is going to ask you the old sections. Please start remembering the new sections. Ma'am, could it be said that the competency to try here depends upon competency to punish? These are two different things. Competency to try is different and competency to punish is different. Competency to try, you can say it is in Schedule 1, and competency to punish is under the code 28 and 29 or 22 and 23. But these sections are not important, but this is the actual picture. So these are two different things. These are not coterminous. These are nowhere related to each other because a person who's not even competent to give 4 years of punishment is handling such cases which have 7 years minimum punishments if you look into the schedule. So you cannot say that.
But once they realize that it has an amount of 7 years of punishment, they are committing it to a higher court, right?
After committal, yes, you can say that. After using the weapons of committal and submission, yes, then they cannot try the offenses which are not in their, they cannot inflict more punishment. There is a meaning of giving section 28 and 29 or 22 and 23, right? Because otherwise the whole point of giving these sections will be futile. So obviously after using these weapons, because of making it happen and because of making a relation between these, like not making a relation, but making a balance between these two provisions of the Bayer Act, the weapons of committal and submissions are provided. You can say that.
Ma'am, also once the lower courts realize that this is beyond their punishment giving power, it is mandatory that they have to either commit or submit, right?
It is a kind of mandatory thing. Obviously, they cannot do that. They can not move ahead with the case which are not under their limits of punishment for trial. Shall I move ahead now? Any other doubts, Aisha?
Yes, ma'am.
Okay, so the last concept of courts, hierarchy of courts, understanding how courts work will be either withdrawal or transfer of cases by the high courts. The high courts. Okay, now this lets me come to the point that this is section number, for the point of view of old section, it is 407, but the new section is 447. You can open 407 in your Bayer Acts. You guys might have heard that the High Court is not a court of original jurisdiction. Yes. Go ahead.
But it is it has an original jurisdiction to the extent of accepting writ petitions, but otherwise it's a court of appellate jurisdiction.
Apart from the court, yes, apart from the writ jurisdictions, and Supreme Court ke liye bhi that is applicable, apart from the writ jurisdictions and apart from the PILs and apart from few weapons which are provided under Constitution, High Court is not a court of original jurisdiction, but then also it has one exception under section 407, 447, clause 3 or 407 clause 3. Court of Session is not a court of original jurisdiction, and this does not have any exception. This is provided under 193, or it is for the sake of new laws, it is provided under section 213, where it is clearly mentioned that the court of, and you will be able to connect the dots now. Why Court of Session is not a court of original jurisdiction? Because anytime the cognizance is taken by the judicial magistrate and then they are committing it to the Court of Session, they are not taking cognizance anyhow. They're not taking cognizance either on the police report, they're not taking cognizance either on the complaint, they are not taking cognizance suo motu, they are just having the cases, whatever the committals are, they have the committals, or whenever, because they have such committals which are very grave in nature. That is why Court of Session is not a court of original jurisdiction. Clear till here? This does not have any exceptions.
Could you repeat the sections for the old law under withdrawal? What is the section? And Court of Session is not an original jurisdiction. What is the section?
It is 193 old law and 407 old law. 407 for transfer of cases and 193 for Court of Session, not an original jurisdiction court. The screen is visible, I think.
Yes, ma'am.
Yes, ma'am.
Okay. So let's quickly move to 474 of the new act. You guys can open 407 of the old act if someone is having the old act. And please read it for me. Okay, this is 447, I think. Yes. Please read it for me, section 407 from your whereas.
Power of High Court to transfer cases and appeals. Whenever it is made to appear to the High Court that a fair and impartial inquiry or trial cannot be had in any criminal court subordinate thereto, or that some question of law of unusual difficulty is likely to arise, or that an order under this section is required by any provision of this code, or will tend to the general convenience of the parties or witnesses, or is expedient for the ends of justice, it may order that any offense to be inquired into or tried by any court not qualified under sections 177 to 185, but in other respects competent to inquire into or try such offense, that any particular case or appeal or class of cases or appeals be transferred from criminal court subordinate to its authority to any other such criminal court of equal or superior jurisdiction, that any particular case be committed for trial to a court of session, or that any particular case or appeal be transferred to and tried before itself.
Okay.
2.
Okay. So these three are the grounds on the basis of which the High Court can transfer cases to any other courts for the requirement of fair and impartial inquiry, or the trial cannot be held in any criminal court subordinate, that some question of law has unusual difficulty and is likely to arise, or any other under that any that an order under this section is required by the provision of this Sanhita, or will tend to general convenience of the parties or witnesses for the ends of justice. So this makes the scope of the High Court to transfer the cases to any subordinate courts huge. Clear? This is just for your understanding that the High Court can transfer any of the cases because of these three grounds, which are basically everything and anything which may arise on the basis of which a court can transfer a case to anyone, any other court, the subordinate court. Clear till here?
Yes, ma'am.
It also can order that on the basis of jurisdiction, your barracks would have 177 to 189, right? These sections are relating to jurisdiction, the area territorial jurisdiction. With the example which I gave you, Bilaspur and Raipur, the example, Mumbai or Pune, any two districts example you can take, or any the jurisdictions which are divided in a state or a district. Then if the court thinks that yes, this particular court is the state high court thinks that this particular court is not eligible to try the offense because of the territorial jurisdiction, they can transfer the case. Then in case of appeal or any cases of appeal, the court thinks that the case has to be transferred from one criminal court subordinate to its authority or any other criminal court of equal or superior jurisdiction. Okay, so if in case of appeals also, the High Court have same powers. We'll read the provisions of appeal and we'll understand the appeal, the lower, the JM second appeal lies to whom? The JM first appeal lies to whom? Obviously, the exact above authority. And if in case the court thinks that the transfer should be between them, the court can do that. Now that any particular case be committed for a trial to a court of session, why always the word committal is used for court of session? So always remember that the word, as I started the class yesterday with, like I told you in the very beginning, that these words committal and submissions may sound very easy and may sound very different from what they actually mean. The meaning, for example, the meaning of the word appeal is very simple, appeal. Bail is very simple, bail. But the territorial jurisdiction is territorial jurisdiction. But committal and submissions, they actually nowhere connected to what the concept of committal and submission are. So it will be always confusing to understand committal and submission. So always remember C equals to S and S equals to C. This is how I remembered when I was not able to understand, like not able to memorize. Committal is to sessions and submissions is to chief. That means the chief judicial magistrate. Always remember that. CSSC. So committal is to the court of session, that any particular case be committed for trial to the court of session. They can order that. So now what is the actual meaning of it? If suppose committal always happens to the above authority. So suppose a JM first is trying a case, or maybe a CJM is trying a case. The court of session, the High Court can interfere between the proceedings and ask them to commit it to court of session. Clear? So you had the doubt, somebody had the doubt that how, if the court takes cognizance, even if they are not empowered to do that, then what? And High Court is there, the superior authorities are there to supervise it.
Ma'am, can you repeat point number 1? like section 447(1.1).
These grounds?
No, ma'am. The not ABC.
The order, the
First
point of
one.
order.
Yes, yes, ma'am.
197 to 205 are the provisions of dealing with territorial jurisdiction of a court. So this is one of the important things how a court can proceed ahead with the trial. Because suppose if a person is a judicial magistrate of district X, obviously they cannot try a case happened in district Y. This is not possible. So this is very practical that this cannot happen, right? So because of this, because of lack of territorial jurisdiction, if a case they think a judicial magistrate has taken cognizance, or after taking cognizance the jurisdiction changed, or there are matters where there are two or more jurisdictions, a person resides somewhere else, the case happens somewhere else, he would be traveling, what will be the cases if he would be traveling? So all those cases, if there is a doubt, high court will take the supervision ahead, high court will interfere and transfer the case to the person and transfer the case to the court who is competent to try in matters relating to territorial jurisdictions.
Understood.
Could you again explain the part where you were saying that the magistrate doesn't have jurisdiction in itself, so High Court is there to supervise and transfer it to court of session, like you were explaining a bit earlier. So could you explain that again?
Yes. So basically, committal happens to the court of session always, right? Before cognizance and after cognizance. Before cognizance is very clear. If outright jurisdiction is excluded, then before cognizance, the JM first will commit it to the court of session. After cognizance, if the court thinks that yes, now before I was competent enough, after this I am not competent enough to inflict a greater punishment, or because of some complications I need to commit it to the court of session, I'll do that. So these grounds are the grounds for committal. And on the basis of both these two grounds, if a court does not, the JM court does not commit it to the court of session, if that is the case, then High Court can interfere. Okay?
Means even if these two grounds are not followed, the GM doesn't commit it to the court of session, you're saying?
See, for example, a JM first take cognizance of an offense, which becomes very complicated afterwards. Okay? But since this is a basic human nature that we think that we'll handle everything, he's going ahead with the trial and he's not committing it to the court of session under section 362, it is right, 362. 325 of the old law. If he's not doing that, then what happens? It is 364. Then what happens? The High Court can interfere and tell that, see, this is getting out of hands. This is very complicated for you to try it. Better commit it to the court of session. And they can order, not request. Clear?
Yes, ma'am. But how will the High Court in this case know that it is a complicated case, so transfer it to the court of session?
See, practically in a state, whatever is happening in a state, it is the duty of the High Court to supervise it.
Okay.
So High Court will get to know it that this is, if a case is not getting complicated, for example, the case is running for 20-25 years, and this is the case is getting complicated, and this is like the application is made to the High Court, just for an example. Okay. Or not, if not an application is made to the High Court, the High Court knows it, that yes, this is one of the complicated case. The High Court will move it to, like, there is no mandate. I know what you want to hear, that there should be a mandatory provision that yes, the application is made and then the High Court can order that. No, there is no such thing. The High Court has suo motu power in itself to transfer such cases. If he knows about it from any other sources, if he analyzes it, the High Court if it analyzes it, if it has some application or any of the resources it has, he can transfer such cases of committals.
Okay, ma'am. So this power is not coming under the original jurisdiction of the High Court.
No. The original jurisdiction clause. The original jurisdiction clause is clause 4, not clause 3.
Okay, okay.
Okay, so that any particular case or appeal be transferred to and tried before itself. This is very, very important. Very, very important. Fourth of 447.
Ma'am, when you say
Yes.
a court can take cognizance and it also has a suo motu power, what is exactly the difference that comes?
Okay, so
Cognizance and
I'll be dealing with all these things today after I finish with withdrawal. So basically, the difference is the court can take cognizance on 3 grounds. What is the meaning of the cognizance? I'll be letting you know. Basically, to take an to know about something and then to handle the matter in a very basic and layman language. Cognizance means that. So suo motu means on its own. Okay, on its own, as in they did not receive any information of it. They did not receive any complaint of it. They just, the court just saw it. The magistrate just saw it. Then also they can take cognizance of an offense. But there are many conditions to it, taking cognizance suo motu. I'll be coming to section 190 or 210 of the new law very soon, and then we'll be dealing with it. Today is the day for that particular thing only. But for this particular area, you just need to understand that the court, the High Court, even without receiving an application, if thinks that yes, a particular case has to be committed to the Court of Session, which is being tried by a Court of Judicial Magistrate first class or the CJM or any of the Court of Judicial Magistrates, the High Court can commit the case to Court of Session. That is what I meant. For this particular, for point number 3.
Yes, ma'am, understood.
Point number 4 is very important. This means that the High Court can transfer a case or an appeal before itself anytime, even before a lower court has taken cognizance of it. This makes the High Court a court of original jurisdiction. Any case, because particular case is mentioned, not only appeal. Suppose if a case comes in front of the judicial magistrate, and even if he before takes the cognizance of it, the High Court can say, no, you don't take cognizance of it, pass it to me. Even after taking cognizance of it, the High Court can say, pass it to me. Clear?
yes, ma'am.
So this makes the court of High Court a court of original jurisdiction.
Court, High Court, a court of original jurisdiction.
Not able to hear you. Please repeat.
Ma'am, I didn't hear what you said. Are you saying that clause 4 makes High Court a court of original jurisdiction?
Okay. So basically the general rule is it has certain exceptions. For example, though I think you only gave the example of writ petitions. The general rule is that the High Court is not a court of original jurisdiction. Original jurisdiction, by original jurisdiction, what do I mean? That means the High Court cannot take cognizance of an offense, or the High Court cannot try an offense on its own. The High Court only tries appeals or the cases which are being transferred from lower courts. But this is one of the exceptions of this general rule, that any case or any appeal at any state point of time, the High Court can ask any court to transfer to him. This makes the High Court a court of original jurisdiction. This is one of the rare situations. This is one of the exception situations which happens. And Through this, the court can take cognizance of any offense, the High Court. Shall I move ahead?
Yes, ma'am.
Yes, ma'am.
These are just the procedurals that how the transfer can happen and how the High Court and the other court needs to go on with the trial. This you can read on your own, but this is not actually important from the point of view of your CLAT examination. So for the purpose of CLAT, the only thing which is necessary to remember is that the High Court is not a court of original jurisdiction, but yes, they can transfer any case to for trial before itself also, or they have huge power of transferring cases from one court to another on the grounds of territorial jurisdictions or on the grounds of failure of justice to meet the end of justice, fair and impartial inquiry, or if the High Court thinks that any question of law has unusual difficulty, and the most important thing is if they think that committal needs to be made to the Court of Session, they can do that.
There's a doubt in the chat box which you can address also.
Sure. I will not be able to see the chat box till the time I'll be sharing the Bear Act. As soon as I'll come back to the whiteboard, I'll be able to see it. Okay. Ma'am, is there particular kind of offenses on which High Court can take cognizance itself? Okay, now let me come to that again. So, if you'll open Schedule 1, what courts you can see? Column 6. Can you see High Court anywhere? Because actually, High Court is not a court of original jurisdiction. That is the reason High Court is never mentioned in front of any of the offenses. It is any other laws where for any other laws also the Schedule 1 prescribes which courts have to take the cognizance, right? I told you yesterday, the limits of punishment is given, the Court of Session is given, for judicial magistrate first class is given, or any magistrate is given, but not the High Court. Clear? But if you read section 21, or for the old Bear Act, it is, I think, 26. If I'm not wrong, yes, it is 26. If you'll read section 26, the other laws can be tried by, or the offenses under BNS also can be tried by the High Court. That does not make the High Court a court of original jurisdiction. This means that the cases of transfers or appeals, or whenever there is a need for High Court to interfere under section 447, 4, I think 1-4 hai. 1-4. Then in such cases, the High Court can try the offenses. Otherwise, the High Court is not a court of original jurisdiction, and Court of Session is not a court of original jurisdiction. And this does not have any exceptions. It is not a court of original jurisdiction. Only exception is 199, section number 199 of old CRPC, where there are cases of defamation made to vice president and president. The new section is 222. This is the only exception. This is the only one exception in all the laws where the Court of Session can directly take cognizance, where the defamation prosecution are being held against the vice president or president or certain other very high authorities. We'll read the sections in detail. The last point about High Court, Court of Session is clear. JM, the court, so we started with the hierarchy of courts. High Court, court of session, JM1, JM2, and executive magistrate. We started from here. Now you know a lot about court of session, obviously. You know a lot about JM first and JM2. You know the things which executive magistrates are empowered to do. You know a lot about high courts also, but you don't know what procedures these courts are following. So the procedures mentioned under, let me share my Bear Act only. Your old Bear Act will have older, your old Bear Act will have old chapters. I remember the chapters, although it starts from chapter 18, if I'm not wrong. 225, section 225 of the old laws. I'm just telling you because you need to locate what I'm saying, not because you need to remember it. For the new provisions, it starts from chapter number 19. Yes, it was chapter number 18 under the old law. Chapter number 18 is the trial before a court of session. This chapter has all the procedures of trial before court of session. Chapter number 20 is trial of warrant cases by magistrates. That means when a warrant is issued, then how the magistrates are going to try the offences. That means the trial by the magistrate courts, which are they are further divided into two parts: police report and complaint. Otherwise, on police report means complaint. I'll let you know the meaning of police report and complaint just after I help you navigate the kinds of trials. Then trial of summons cases by magistrate. Magistrate can try or obviously the offences through summons or through warrants, and then the summary trials. Is there a procedure for trials by High Court?
No, ma'am.
It is not mentioned in the code. So where it is mentioned in the code, in the Bear Act, that what procedures High Court should follow. It was 474 earlier. The new section is 520. 520, directly scroll down to 474 of your old Bear Act or 520 of the new Bear Act. This is the section. Otherwise, then under 447. 447 was transfer of cases, which we just read. It shall, in the trial of the offense, observe the same procedure as the court of session would observe it if it were trying the case. Now, the question is, what if the High Court transfers the case under section 447 to itself? This is 447. What do we mean by 447 here is 447(4), obviously, because then only the High Court can try the cases. 447(4) or 4074. When the High Court is trying a case before itself, then in such cases, what happens? What should be the procedure? For all the other cases, the procedure of court of session has to be followed. Whenever a High Court is dealing with any application, it is mentioned under 520. But when the court transfers a case from any other court, suppose it transfers a case from JM first, it will try the case as a magistrate only. Or if it transfers a case from court of session to itself, it will try a case as a session court. All the courts have different procedures. All the courts have different, like not major differences, but yes, the procedures are different for all the courts. And also, if the court summons an accused, the procedure is different. Or if a court issue a warrant, then the procedure is different because of few complications under issuing of warrant. That is why. Otherwise, all the other things are very similar if you talk about trial. How a trial looks like in a court, it simply looks like appreciation of evidences, examination of parties. Examination can have cross-examination, examination in chief first, then cross, and in some cases, if required, re-examination, obviously. Then again, appreciation of evidence, and then, pronouncement of judgment. This is how a trial looks like. So these things will be very similar. And from which stage the trial begins? Can someone answer?
After framing of charges.
Frame.
Yes, as soon as the charges are framed, the trial begins. So as soon as the charges are framed, guys, are you guys able to understand all the others?
Ma'am, could you again explain the trial part, the
Yes, ma'am.
points which you mentioned?
What does a trial look like?
Yeah.
Okay. So a trial looks like as soon as the charges are framed, the trial starts. Evidences are collected. Then examination of parties happens, which will contain 3 stages of examination. We'll study in Indian Evidence Act in detail. What is the difference between chief examination, cross-examination? You might all know what is chief examination and cross-examination. What happens if you have seen some law-based movies also, if someone has not done the internships, then also they might know what examinations look like. Then appreciation of evidence, and then the judgment. A lot happens in between in actuality, but this is what the chapters look like. Chapters of procedures of trial look like. So High Court, what I meant to say was the High Court has no procedure of itself. High Court follows the procedure of Court of Sessions apart from Section 447 Clause 4, where they transfer the case to itself, and whenever they are transferring a case to themselves, they are adopting the procedure of that court from where they are transferring the case. Clear?
Yes, ma'am.
Shall I move ahead?
Yes, ma'am.
Okay. So this was all about the courts and related provisions. With the courts. We'll read the sections, but before that, I will have to start with cognizance today. Otherwise, you'll not be able to understand the concept. And then we'll be reading the sections. And I think a doubt class is required. And I think a clearance of all the concepts which have happened till now, including submissions, committals, transfer. All these 3 concepts are required to be revised again. Whoever want to attend the class can come. I'll request sir to have an extra class maybe on Sunday or Saturday, whatever is fine with them, and then we can have the class. Okay? Because a lot of people are not able to understand. I have a chat, I think, after charge framing. Yes. How many of you are not able to understand these 3 concepts very clearly? Committal, submission, and withdrawal. or transfer? You can raise your hand so I can arrange a class, then we can talk about in detail because I have to move ahead with cognizance. If you're not able to understand how a court works, then you'll obviously not be able to be very clear with, okay, thank you, Venkat. So you'll not be able to be very clear with the concepts of taking cognizance. Basically, till now we dealt with the number of courts CRPC has and or the BNSS has, and their powers, their functions, and how they take cognizance and how they actually work. This is how we are moving ahead. And now I'm talking about cognizance. Okay. I'll ask sir for one extra class on these three topics. Okay. Cognizance. What do we mean by the word cognizance?
Ma'am, to take judicial notice of.
Right. Judicial notice. This is the actual meaning of it in the legal sense. But in the layman language, cognizance means a court is taking the charge of the offense, taking the responsibility of a trial, taking that, yes, I am going to see it. I'll be taking the charge and I'll be seeing whether I'll be able to do it or not. I'll commit it to somebody, the court of session, or I'll send it to somebody else, or I'll try it myself. Whatever the situation is, I'll be the person who will taking the charge of it. So cognizance means, in simple language, the power to handle a case. But in obviously in legal language, it means taking judicial notice of a case. Clear? This is the simple meaning of cognizance. Now, cognizance, there is a definition of cognizance in your Bayer Act, cognizable offense and non-cognizable offenses. But it only says that the offenses which are mentioned under section, the schedule 1 are as treated as cognizable, and the offenses which are not the mentioned under schedule 1 are not treated as cognizable, non-cognizable offenses. It only tells you about the schedule 1 and cognizable offense. They say for cognizable offenses, the Bayer Act says that a police officer can arrest without warrant in a cognizable offense. Can somebody tell me the reason behind it? Why cognizable offenses, under cognizable offenses, the police has an authority to make arrest without warrant?
They're much more serious offenses.
Exactly. Exactly. That is the whole point of it. Otherwise, why the police officer will be getting the power? But you cannot, differentiate that, yes, theft is a very small offense, murder is a serious offense. The theft should be cognizable. This is one common thing where if such a question comes that which of the following offense is cognizable, which is very like never happened in CLAT and never happened in any other exam also. But because everyone cannot remember all the sections of IPC, 511 offenses of sections of IPC, which offense is cognizable and which offense is not cognizable. So this depends upon schedule 1. Now 2G defines cognizable. This is the important section. You need to remember it. 2G, not the old law. Okay. 2G and 2O are the new sections. It simply says a police officer has no authority to arrest without warrant. It actually the definition doesn't tell you that how the procedure will go ahead if the cases are cognizable or the cases are non-cognizable. It is the Bare Act and it is the subsequent chapters which have all the procedures relating to cognizable and non-cognizable offenses. Clear till here?
Yes, ma'am.
Okay. Now let's come to section 190, or you can say 210 of the new law. 210 of BNSS or 190 of CRPC. This is very important. Clause-wise section, this is important clause-wise. Each clause is important so far as section 210 is concerned. This is exactly same what you saw in what you can see in your old Bare Acts. This is exactly same. This cannot be changed because this is the foundation of CRPC and this is how the proceeding starts after the investigation is finished. So let me just show you section 210 because I am opening the new Bare Act. You can open 190 if you have the old Bare Act. This is the section which is very, very important from the point of view of each and every exam, including CLAT. This is the basic of everything because this is helping courts to initiate the proceedings. How court is going to take cognizance. We understood that yes, FIR is filed or maybe complaint is made. Then what happens? The police report is filed. Then what happens? The cognizance is taken. But how the cognizance is taken, on what basis the cognizance is taken, this section is empowering any magistrate of the first class and any magistrate of the second class, specially empowered in this behalf under subsection 2, that means by the chief judicial magistrate, may take cognizance of an offense upon receiving a complaint of facts, including any complaint filed by a person authorized under any special law which constitutes such offense. For example, 138 of NI. They are complaint cases. Upon a police report, this is something new. Electronic mode. Now electronic mode police reports can also be submitted. Upon receiving information from any person other than a police officer or upon his own knowledge that such offense has been committed. So let's decode and interpret section 190 first, or 210. So the basic meaning of 210 is how the magistrate is going to take cognizance. So what all magistrates are empowered to take cognizance is JM first. Clearly, JM first is empowered to take cognizance without any ifs and buts. It is mentioned. Why it is not mentioned Court of Session, High Courts, all those courts are not mentioned. Why?
They are not of original jurisdiction.
Yeah.
Yes. And why CJM is not mentioned? Because CJM is one of JM, the judicial magistrates only. Right? That is the reason why JM first, the CJMs cannot take the cognizance. Otherwise, it is very basic that the JM first has to take the cognizance of any of the offenses. So for
Yes, ma'am.
example, yes. So for example, let's take we'll get back to JM second very soon. First, understand the three kinds of cases here. The first case says very simple, police report. I always explained you the process of police report. FIR is filed. Then what happens? Charge sheet, cognizance, issue of process, documentations, transferred, then charge framing, trial. Correct? If an
Yes, ma'am.
FIR is received, police report is made by the police officer. As soon as the FIR is lodged by the police officer, they investigate the case, collect the evidences, do the investigation, prepare a police report, submit it to the magistrate. The magistrate take cognizance under section 210(1). Okay, on a police report. This is not taking cognizance on FIR. Many of us get confused that this is an FIR case, so that is why the FIR the police is taking cognizance. But no, this is taking cognizance on the police report, because police report is the channel through which a judicial magistrate is taking cognizance. Second case, when a directly a complaint is made to a magistrate, then what happens? Directly the cognizance happens. The proceedings of complaint takes place. Then either the complaint is accepted or dismissed. This is the complaint case. Then issue of process, appearance and non-appearance, documents are transmitted, charges are framed, and then the trial begins. This is the complaint case.
On what falls under proceeding?
What falls under?
Proceeding?
Yes, I'm letting you know. Noted it? These are the two important, like these are the things which you have to note down for your future remembering of 210.
प्रोसीडिंग के बाद क्या लिखा है?
Complaint is dismissed. Or accepted. Issue of process, documents, charges framed, and then the trial starts. So basically, if a direct complaint is made to a magistrate, suppose the police is not accepting the FIR, accepting to lodge the FIR, then a person makes complaint to the magistrate. The magistrate take cognizance on it. Then they do the proceedings of complaint. See whether the complaint has some substance or not, whether the complaint is actually right or not, whether it is fake, whether they can move ahead with the proceedings, and on that basis the complaint is either dismissed or accepted, but the cognizance is taken before the proceedings. Then if the complaint is accepted, then they call the necessary persons, they give the documents to the accused, the court frame the charges, and then the trial happens. Now, suo motu, which was the third and the most important clause. Suo moto means on its own. This word means on its own. So if a magistrate sees or receives an information, or even if he does not receive an information, and it is clearly mentioned that the information has to be received otherwise from the police officer, that he cannot receive information from police officer, not from police officer. And also, if he does not receive any information, if he sees something, if he knows something, that magistrate can take direct cognizance of the offense.
This is where the magistrate reads on a newspaper, or basically if the case is sensationalized, so that's when. Okay.
Yes. Yes. But there's a catch to this this power of magistrate, because otherwise it will be, magistrates are also human beings. I know they are judges. They are treated to be very respectable part of our society, and they are made judges because of some very valuable reasons, and they have to be impartial. But yes, this is huge, giving them suo moto power to take cognizance of any and every offense is huge. That is why whenever the powers are limitless, a restriction is imposed. And the restriction of clause 210(3) is given under the new section is 211. And the old section was 191. The 190 and 191, 193 and 191 have to be read together. Now 210, 3 and 211 have to be read always together. 211 is only talking about where the magistrate take cognizance on its own.
Clause 3.
Yes?
Ma'am, there are only two clauses.
210 clause C. C, A, B, C. Not 1, 2, 3. A, B, C, C. You can write it this way. This is 191. This is 210 1A. This is 210 1B. And this is 210 1C. Now clear? 210 1C has to be always read with section 211. 210 1C is always to be read with section 211. Clear now?
Yes, ma'am.
So 211, before moving to CJM second power, let's see 211 first. 211 talks about when a magistrate take cognizance of an offense under clause C of subsection 1 of 210, that is the suo moto cognizance on its own, because the power is very limitless and there are high chances of the magistrate getting biased because he himself has seen the offense, he himself has perceived the witnesses, he himself has done everything. The accused shall, this is a mandatory provision, before any evidence is taken, be informed that he is entitled to have the case inquired into or tried by any other magistrate. Even the inquiry can be transferred, and trial, so chalo, that has to be transferred. And if the accused or any of the accused, if more than one, objects to further proceedings before the magistrate taking cognizance, the case shall be transferred to such magistrate as may be specified by the CJM in this behalf. You can refer to 191 if you haven't opened your Bare Acts. Or just see on the screen. So this is one of the restrictions which is put upon the limitless power or given to magistrates to take suo moto on its own the cognizance of any offense under section 210(1)(c), that under section 211 it is mandatory for the court to inform the accused or more than one accused, if there are more than one accused, that they have a right to get the trial and inquiry also transferred to any other competent court. And if they say yes, then it has to be done. This is mandatory. Clear?
Yes, ma'am.
Let's understand before going to the other difficulties and other problems. Let's, for the change of mind and for reducing the heaviness of the session, let's recall a very landmark case and a very historical case which is going to be there forever in the history of India or the world history, because this was not resolved. I am referring to 6th January judgment, which relates to cognizance. The 7th June 2012 judgment is the final order, but I am referring to 6th January judgment because it went for so long, you know. By the name, you know what I'm talking about, right? Can anybody tell me which case is this?
Arushi Talwar's case.
Yes. Because Nupur was her mother, that is why the name is Nupur Talwar versus CBI. Because the case was filed against Nupur Talwar. Why there was a question of cognizance here? See, there were clearly three teams who investigated the offense. Police, what happened with the police officers, we all know. They did some gross mistakes with the primary investigation, and that is why the case is still unresolved. So they did not find anything. They filed the closure report. What is a closure report? When you think that nothing is found and you do not have any evidences against anyone, you file a closure report. The police files the closure report. Then CBI 1, team 1 came into the picture, and then CBI 2 came into the picture. CBI 1 were in favor of the parents. CBI 2 were against parents. So obviously, when CBI 1 filed the closure report, the case went, because of the sensation it was getting in the country, it went to CBI 2. Then CBI 2 found some evidences, and those evidences were, first, it was the last seen theory. Last seen theory is what? Basically, that is very obvious. Those who are alive and were at the scene of crime at the time of the crime are the prime suspects. So the two persons who were there at the scene of the crime were mom and dad, Rajesh and Nupur Talwar. Second was the kind of throat slitting. It was very clean. Can somebody tell me why it is an evidence? Why it is an evidence? Because
Ma'am, because it
Yeah.
indicates that Arushi Talwar was killed because of the slitting of throat, and then maybe it could lead further to a way of resolving the case.
No, but because Rajesh was a doctor. Mr.
Oh
Rajesh
yes, ma'am.
Talwar was a doctor. Arushi's father was a doctor, and that is why I think mother was also a doctor. So that is why the kind of throat which was the manner in which it was cut, it was very clean, and a doctor can only do that. That was the contention of CBI team 2. Third was the terrace. Yes, both of them were doctors. Yes, correct. Terrace, and that is why it directly led to the kind of slitting also. But this is also not a direct evidence, we all know. Terrace, the door of the terrace was closed, I think, from inside. Yes. The door of the terrace was locked from outside and they hid the key. This was the third thing. Fourth was their behavior. These were the four evidences which CBI team 2 can figure out against the parents, because their behavior, the parents' behavior was not very usual. But since all these evidences are not directly leading to the conviction of the parents, because this is not even circumstantial evidences. That is why CBI 2, please draw your attention here. This is very important, and this can be a question in your CLAT paper also. Because there was a question from, like, in past few years, I saw it. CBI 2 filed a closure report. Closure report is what? That we do not have any evidences for, like, the substantial evidences against anyone. We are also filing the closure report. Against that closure report, a protest petition was filed. Protest means what? To protest. To not to treat it right by the parents of by the parents of Arushi Talwar themselves. And then the court take cognizance against the parents only. So this is the history, that this is once ever happened in the history of the country, that those who filed the protest petition, those who claimed against that this closure report that this is wrong, the cognizance was taken against them only. This is Nupur Talwar versus CBI. So this taking cognizance by the court was very controversial, and that is why cognizance, this is one of the landmark cases if you talk about cognizance, the 6th January's decision, not 7th June's decision. 7th June decision is the full-fledged order, what happened and why court did not convict the parents, and because of the lack of evidences, obviously. But since the court take cognizance on these grounds, there was a huge controversy in the country. Clear?
So basically, ma'am, despite a closure report, a magistrate can take cognizance, is what this
Yes.
case says.
Yes,
Okay.
they can take cognizance. Then what happened was, you can note this down, that the court held in the 6th January decision, that is just based on cognizance, order, not decision, order you can say, that if a prima facie case is there, this is what was held. This is the most important thing you need to know. No need to note this down because you already know about it through some sources or other. There are a lot of movies on Arushi Talwar's case. One being the super hit movie. I think Irfan Khan was the hero. So you can see that movie. The whole picture of the case will be clear. Irfan Khan led the team 2 of CBI, who thought that yes, parents are the culprits, and team 1 was held by, I think, someone else, Anupam Kher, if I'm not wrong. Then they thought that parents are not guilty. First of all, they thought the servant was guilty, and then the servant was also found dead on the terrace. So if the prima facie case against the accused if there is a prima facie case against the accused, cognizance can be taken. There were several evidences which suggest that the accused have some sort of involvement. You can write this down because this is, how landmark this is. I even don't have to tell you. This can somewhere or the other will always have bright chances of being asked, either in CRPC or under Constitution or under IPC, whatever you say, name it. This case has involvement in it. So broadly, what is meant by the court is there has to be a difference between cognizance and the full-fledged trial. Okay. So it does not matter if the evidences are not enough, but if there is a prima facie suggestion, that yes, the accused has some sort of involvement, the cognizance can be taken. If the accused has committed the offense or not, that is what has to be decided under the trial. That cannot be decided before taking cognizance. And that cannot be one of the factors to take cognizance. So that is why it becomes important from the point of view of cognizance. One more point it had was that because of all these controversies and because of all these blames to the court which took cognizance of the offense, there was something which was challenged, that the court gave a very long, if you'll see 6th January's order, it is a very long order which was only related to cognizance. So usually who saw the orders in the court or who used to go to the courts, they might know that the order of cognizance is very short. So yes, I take the cognizance. Like there's nothing to write much. But in this case, the order of the, I think, 200 pages order was there just for why they took cognizance on these grounds. So the court held that it is not wrong to take cognizance. It is not wrong to give a detailed order. Not wrong to give a detailed order for taking cognizance. Don't write these shortcuts in your exam whenever you are having your college exams or any descriptive exam in future, because this will help you deduct your marks very easily. I'm using it because we are running out of time. So detailed order for taking cognizance, not wrong. The code is not wrong to give a detailed order of taking cognizance, because there is a provision of appeal against cognizance. Next week, I would want you to write down the number of judges, the court which took the cognizance in the Arushi Talwar's case or the Nupur Talwar case or the double murder case, and not to read the judgment, but yes, the number of judges, the name of the judges, and which court took the cognizance of the, and which court gave the order of the, like it was very obvious it was the Supreme Court, but yes, you need to see the hierarchy of the courts for next Monday. And then we'll be beginning with investigation, inquiry, and trial.
Okay, ma'am.
Any doubts?
No, ma'am.
No, ma'am. Ma'am, also for the weekend test, there's Adivasi case that is coming.
Yes, I'll be giving the test by Friday, and you will have the test by on Sunday. I am supposing that. I am not sure about the day on which you are having the test and the time. You will have to confirm with sir. But I was told to give the test on every Friday for whatever topics I am like the week has covered. And so basically, since we are in the introduction part, the only cases which are important from the point of view of these three topics were, you already know, the tribal areas case, Nupur Talwar and Arushi Talwar's case. Just a second. I hope I'm clear. Any doubts, guys? I would request a revision class for sure. And then we'll revise everything what is taught till now, because I know the topics were heavy and it's a lot to understand. Can somebody tell me, is this the way you studied in college?
No, ma'am. For me, no.
No, ma'am.
Not at all, ma'am. No, no. No
No,
way.
ma'am.
Rishabh?
No, ma'am, it's like better. Ma'am, you are teaching in depth.
So this is where we find the difference between college and whatever the practicality is, because law is very practical in nature, right? Not bookish at all. So yes, let's see you guys on Monday. I hope we'll have a class before Monday also, the doubt session, and then we'll resume on Monday. Okay?
Sure, ma'am. Thank you.
Thanks
Thank
a
you,
lot.
ma'am.
Ma'am.
Bye,
Bye.
ma'am.